And as advocates, we make decisions, but we're responsible for those decisions. You made a decision here. You made a decision to try to strip a young girl of her anonymity, and you effectively succeeded because you bullied her into it. So she, unwilling to be intimidated by you, went forward and revealed her own name, which took, by the way, tremendous courage. And I'd just like to honor her for her courage in doing that. But you put her to that choice. You did.
Help me understand what I'll refer to as the St. Paul's case, the civil litigation. In the civil litigation, what did the plaintiffs allege?
The plaintiffs allege, Senator, that the school failed to protect Miss Prout from being by Owen Labrie. Right. The claims were in negligence and breach of fiduciary duty and Title IX.
And what were the plaintiffs asking for in damages?
They were asking for civil damages in the form of monetary relief, Senator.
How much?
Senator, I can't recall specifically if there was a request made at the onset of the case, and I certainly can't speak to the aspects of the case that involve a confidential settlement.
I'm not asking you about the settlement. I'm asking you about the allegations. Were they in the hundreds of thousands, millions?
I don't recall, Senator, and I don't believe that they necessarily would have had to specify that in the complaint when they filed it.
All right. You were in state or federal court?
This was in federal court in the District of New Hampshire, Senator.
Okay. And at some point, you filed a motion with respect to the naming of the minor. Is that right?
That's correct, Senator.
Tell me about that motion.
The family of the minor.
But tell me about the motion first.
So they filed the motion seeking the protection to proceed anonymously.
Oh, so it was their motion.
That's correct. We had the school had an opportunity through its counsel to respond to that motion, and the school agreed to allow the family to proceed anonymously at all pretrial phases of the case, and asked the judge as a condition of that to require the lawyers to try the case in a court of law and not in the media. We, as the lawyers approached the case, the school's perspective was that the request for the lawyers to try the case in the court of law as opposed to the media was fully compatible with the family's request to proceed anonymously and with privacy.
Okay, so I'm just trying to understand. So the plaintiffs filed in the name of Jane Doe. And then the plaintiffs filed a motion. You didn't file a motion. The plaintiffs filed a motion to continue to ask to continue anonymously. Is that right?
That is correct, Senator.
And then the position of the school, you went to your client, St. Paul's, and said, how do you want to respond? And St. Paul says, we'll agree to that so long as the plaintiff's lawyers don't try this case in the media. Is that correct?
The position the school took was that they would agree to that provided that the lawyers didn't try the case in the media.
Okay. Was that your position or was it your client's position?
That was the school's position, Senator. I was just an advocate advocating for my client as I had a duty to do.
Okay. So that's what your client told you to file this response. You did. I'm assuming that St. Paul's School was getting the hell kicked out of it in the media. I'm not saying justifiably or not. I'm just stating that as a factual matter. And then what happened?
The judge never got to hear the motion that was filed, Senator, because the family that had filed the lawsuit elected to withdraw the motion before the judge could consider it.
And what was the effect of that?
The effect of that was that the motion that was filed became moot and the judge didn't need to address it and never addressed it. What I can say...
And so the plaintiff continued anonymously?
No, at that point, the family elected to proceed without using pseudonyms, Senator.
So the controversy then is about a motion that the plaintiffs filed that you responded to on behalf of your client, and the motion was never resolved, and the plaintiffs then decided to use real names. Is that right?
Mr. Delaney, I've been listening to your answers about your conduct in the St. Paul's case, and I have to tell you, I'm having a hard time following what it is you're saying. You've said now several times that the school only wanted the court case to be tried in a court of law, not in the media. But your attempt to strip anonymity from Chessie was exactly an attempt to try this case in the media, right? It was an attempt to bring her name forward so everybody would know who she was. She's 16. Everybody would know exactly who she was, could look her up, could threaten her, intimidate her. I mean, this was an attempt to put her squarely into the media spotlight nationally, right?
Senator, thank you for the question. I respectfully disagree that the school's intent in trying to require the lawyers to try the case in the court of law was in any way intended to intimidate any of the parties to the case.
How can you say that when you knew full well that a 16-year-old girl would have her name published, would have reporters, no doubt, in her front lawn, would have people following her around with cameras everywhere? Her family's sitting here today. They've already been through hell. Your motion was an attempt to put them through further hell in order to defend your client, right?
Senator, I was an advocate for the school.
I understand that, but as advocates, I have been too. And as advocates, we make decisions, but we're responsible for those decisions. You made a decision here. You made a decision to try to strip a young girl of her anonymity, and you effectively succeeded because you bullied her into it. So she, unwilling to be intimidated by you, went forward and revealed her own name, which took, by the way, tremendous courage. And I'd just like to honor her for her courage in doing that. But you put her to that choice. You did. That was your choice. So that's fine. You made the choice, but now you're accountable for it. So let's have some accountability here. You deliberately did this in a way that would put her at risk, and that was your intent. Have you read the letter that she submitted to this committee?
I have read the letter that was submitted to this committee.
Let me read some of it to you. She says, and I quote, "I remember so clearly reading Michael Delaney's motion from front to back when I came home from my new high school one day, processing what it meant, and then defiantly stating to my parents that after everything I'd been dragged through, from anonymous death and threats on the internet to the betrayal of and backlash from my closest friends at school, I wasn't going to let Michael Delaney's dirty tactics bully me, then 16 years old, into shame and silence." She goes on, and this is important. "When survivors of sexual assault, harassment, and abuse come forward to seek some semblance of justice, there is an army of attorneys with a tried and true playbook of tactics to discredit, pressure, and manipulate survivors and victims into silence." Those were the tactics that you used, Mr. Delaney.
Senator, I respectfully disagree with that characterization of the role I played as an advocate in the case. The school agreed to allow the case to proceed with anonymity. I have...
No, you didn't. You filed a motion that specifically sought to strip her anonymity. I have it right here. I've read it, and I've read your reasons for doing so. The school didn't like the time that the parents and Chessie filed their lawsuit. You complain that counsel filed the complaints minute before the clerk of the court's office closed on June 1st, 2016. Well, I'm sorry for you, but I don't understand why your inconvenience about the time should mean that this young woman should have to surrender her anonymity and have her life. She's a survivor of sexual assault, let's not forget. That already happened. You knew that. Why should she have to have her life further destroyed because you didn't like the timing of the filing?
Senator, I represented the school in that case. I did not represent the Prout family. I understood what they went through. The school felt that the request to restrict the lawyers from trying the case in the media was compatible with her desire to proceed with privacy and anonymity.
I don't understand what you're saying. You filed a motion that sought to strip her anonymity. You told the court that it should happen because you didn't like the time at which her counsel filed their complaint because it put your school at an inconvenience. They had to answer reporter questions, you said. Frankly, that seems to me like a small burden to bear after what Chessie went through. So you made the decision. You forced her to come forward. She was brave and did it. And now you're accountable for that. And quite frankly, I'm astounded you've been nominated. I can't believe we're sitting here having this conversation today. And I, for one, will not support your nomination for these reasons. People who put sexual assault victims through this kind of torture shouldn't sit on the bench. Thank you, Mr. Chairman.
So the controversy then is about a motion that the plaintiffs filed that you responded to on behalf of your client, and the motion was never resolved, and the plaintiffs then decided to use real names. Is that right?
I believe that's correct, Senator. Again, my role in the case was as an advocate, advancing.
I get it. That's what I'm getting at. I mean, your job's to protect your client.
I had a duty as an officer of the court to advance my client's interests to the best of my ability, Senator.
What if you'd gone to your client? I'm way over. I'm sorry, Mr. Chairman. This will be my last one. If you'd gone to your client and said, look, well, strike that. I think I understand what happened. Thank you, counsel.